SJC-11177, Commonwealth versus David Vincent.
Okay, let's proceed. Good morning.
Good morning, Your Honor. Attorney Greg Schubert on behalf of Mr. Vincent. I would note from my trial and appellate experience that it's rarely propitious to be the first case out on a Monday morning or the last case to be argued on a Friday afternoon. But I think it's important that I do address what happened on Tuesday with this court relative to the Johnson case. I'd like to take a minute or two to attempt to clarify for the court how I believe that the two cases are contrasted relative to an invocation, relative to Fifth Amendment rights. I would like to point out that this court in Johnson, I believe, nailed it when they pointed out that the difference was that Mr. Johnson chose to talk after he had already had a lawyer. And obviously his statement, which is, "I don't want to talk because my lawyer told me not to talk," is clearly the contrast that really exists between David Vincent's case and Mr. Johnson's case. There was the further allegations of the multiple IAC counts in the Johnson case. I would point out that on behalf of Mr. Vincent in this particular case, I obviously filed one IAC count relative to the failure of trial counsel to raise the, we'll characterize it as safe harbor argument relative to the suppression hearing that was held prior to the trial. What I note for the court is that obviously the trial counsel, Mr. Rhoda, did not have the benefit of either Futinato, which came down in 13, nor did he have the extra impetus of the Bay case. And what I have argued in my case, as you can tell, all stems from the motion for a new trial and the hearing thereon and the rulings that were made by the trial judge in denying it. What I'm basically saying is that those two cases made a sea change, and it made an old lawyer smile that it seemed like Wasung versus the United States was still alive and well. The exclusionary rule had not died, even though we had been told so, and that there were standards that had to be applied in these particular cases by the police. I asked the court to note that I did make a conscious decision in my brief not to mention the Hoyt case. I didn't mention the Hoyt case because I was really interested to see what the government would argue about the Hoyt case in its brief. And I'd like to, in a few minutes, address some of the portions of the government's arguments about that case. But what I really want to point out to this court is that in 2011, we have Hoyt. These are the exact same police officers engaged in the exact same process that they engaged in Hoyt. If an exclusionary rule is to have any effect, if the word prophylactic is to mean anything, then they've got to be forced to do what the court has said that they need to do. And I rarely read from a court decision, but I would like to say that in the Futinato case, the court here actually said the rule of prompt arraignment underlying Rosario serves the broader purpose of not only protecting against unwarranted police pressure on an arrested person to talk. The rule is also intended to facilitate a criminal defendant's right to counsel, to ensure that a defendant receives a prompt statement by a judge or a magistrate of the charges against him, to prevent unlawful detention. The last sentence is really critical in that case because it says, itself is designed first and foremost to address the need to give clear, unambiguous guidance to the police, amongst other, concerning the right to question a defendant who is under arrest. I'd like to bring the courts to attention that in this particular case, when Mr. Vincent walked into the police station, they knew that he was in violation of a 209A restraining order. They knew because they had gone to the Board of Probation and obtained the records. They knew that this was the suspect. He could have been arrested right there. And there is no question about whether or not this was custodial or whether he was under arrest. If Mr. Vincent had said before he even walked up those stairs to the Detective Bureau in the Pittsfield Police Station, "I'm leaving," they would have said, "Oh, no, you're not." They had him. He was under arrest. He was in a custodial interrogation. There can be no argument by the government about that. The facts of the record prove that that's the actual case in this case. I would further point out to the court that when the questioning begins, and as I've laid out in my brief, you notice that the police actually verify events that happen along the line of the timeline, but they don't really say when things began and when they actually ended. That served their purpose. For anyone to believe that the police themselves were actually the people that were really manipulating and handling this particular case is an absurdity in and of itself. This case was being overseen by the Office of the District Attorney, and they should have known that they're in violation of not only Bay, they were in violation of Futinato, and they were certainly in violation of Safe Harbor. My brother in his brief argues about the 6-hour requirement. Maybe I'm wrong, but that isn't really what Futinato says. It says that this is to give a defendant a fair chance relative to questioning and being advised of his right to counsel. That's what that case actually says. Mr. Vincent wasn't given that. What actually happened with Mr. Vincent? Well, when he did stop talking, they took him downstairs and allegedly booked him. Obviously, Justice Spina and myself certainly know the distance between the detective's office and the Pittsfield Police Station and the court. I admit that the road is heavily trafficked, but they could have walked him there. And it's important for this court to note, at least I believe, a critical stage is that in all the murders that I've been associated with in Berkshire County, and in this case particularly too, it seems like there is a shortage of paper forms in Berkshire County. There's never been a waiver of speedy arraignment that I'm aware of that's ever been signed or executed in Berkshire County, in any case, much less a homicide case. It seems that we just ignore this fact. And by ignoring this fact, what are we actually doing? If Mr. Vincent had been walked across the street less than probably 100 to 70 yards, he would have gone in front of a magistrate who would have given him a lawyer, and actually had a previously assigned lawyer relative to the case that he was in default on. And that lawyer would have said, "Don't talk to the police relative to a murder case." It is absolutely absurd to believe that the government wasn't fully aware of that in their obligations under Hoyt and Futinato. Now, my brother makes several interesting things in his brief. One of them is that he says that, well, this is harmless error. Harmless error? Mr. Rhoda was forced to make his opening statement conceding that Mr. Vincent had in fact killed this woman. I would say that that's a little bit beyond harmless error. There's no harmless error here at all. It's really hard to criticize anything that Mr. Rhoda did in the defense of Mr. Vincent based upon the rulings that he was confronted with. He had no right to appeal them. There was no chance until now to raise these particular issues. I regret, actually, in the brief, labeling it as an IAC relative to the Futinato Safe Harbor, because I believe that any competent capital lawyer would have conducted the case with the rulings that he had exactly the same way that Mr. Rhoda did. It's important for this court to note, if you lay down a rule, the police have got to follow it. There isn't much doubt in this particular case as to whether or not the defendant actually murdered someone. It doesn't seem like there's much of that. But if the words outside of this courtroom are to have any meaning for both the general public and for the defendants that come before the bar, then the answer is he's entitled to a fair trial where the police and the prosecutor are made to comply with what this court rules. My brother points out that, he says, well, the United States Supreme Court wouldn't see it this way. Well, I point out to this court has constantly said that Article 12 gives us a few more rights than the federal court does relative to these type of situations. If Articles 12 and Article 29 are to be ignored, then there is no justice. And clearly in this particular case, with the police officers, they already knew. They lived this case in 2011. My brother says in his brief that the key issue here is that Mr. Vincent said, I probably need a lawyer. No, that is not what this case is about. That's one statement. It's clear that he constantly said, I think I need a lawyer. I want a lawyer. He stopped talking. And each time that they did that, it was interesting. One of the things that the police notes point out in this particular case, he says, I want a lawyer. He stops talking. What do? They exit the interrogation room, and then they come back. Do they come back with saying, would you like to contact a lawyer that was representing you previously on this violation? Did they say, would you like to be arraigned relative to this violation? Did they give him a number? Did they tell him about how to contact CPCS? No. What they did was lure him back in to an interrogation situation. It's my argument in this case. This is violative of what this court has ruled in both Futinato. It violates the spirit of that big time. And I argue to this court that in Hoyt, you laid down a standard and they ignored it. They absolutely ignored it. And we definitely know that there isn't a paper shortage such that they couldn't even have gotten him to sign the appropriate papers that this court mandates. They never, ever complied. Mr. Vincent didn't get a fair trial, and when he didn't get a fair trial, he's entitled to a new trial with the suppression. He's not entitled, obviously, for his lawyer to argue that this didn't actually exist. We know that that's the law, but he is entitled to a new trial because those statements should have been suppressed because Mr. Rhoda, his trial attorney, was faced with an impossible situation. The last thing that I'd like to point out to the court is that my brother points out that I raised this issue of the thing late, meaning the Safe Harbor Act, and that I choose to address it on appeal. I chose to address it on appeal so that I could see exactly what the government was going to argue. You do not see. The one thing that's really missing in the Commonwealth's brief is an acknowledgement that this court reversed in Hoyt and the reasons for which they did reverse in Hoyt. That's what this case is all about. Unless there's any other questions, I submit on my brief relative to the other arguments in my brief.
Thank you, sir.
Thank you, sir.
Good morning. May it please the court, John Bossé for the Commonwealth. The Commonwealth respectfully requests that this court affirm the defendant's conviction as well as affirm the motion judge's decision to deny the defendant's motion to suppress. The Commonwealth would first like to briefly address the issue that the defendant was not in custody. As you look at the four factors under Hilton, as well as a recent case decided by this court in Molina, the fact that the questioning took place at the police station does not in fact convert the interrogation, make it custodial. This is a defendant who voluntarily arrived at the police station and agreed to speak with the officers. Additionally, the detective, while she testified that the defendant was the sole suspect, there's no indication that this was ever relayed to the defendant that he was a suspect. Furthermore, there's no indication that the officers were aggressive or loud. Yep.
Now, this was not audio taped or videotaped at the defendant's request?
That's correct.
So all we have a transcript? Or?
Yes, we do have a transcript from the motion to suppress hearing.
And so that means that the motion judge is the one who makes all of the credibility determinations?
Yes, and he found that, well, he never addressed the custodial issue, even though the Commonwealth had argued it in its memorandum in support of the denial of the motion to suppress. But Judge Agostini never addressed it. He went right to the issue whether or not the defendant had invoked his right to counsel. But just finishing with the custody issue, there was evidence at one point Detective Strout raised his voice at the defendant, but other than that, there was no other indication, again, that the officers were aggressive. In fact, the motion judge found that both Detective Kakamo and Sergeant Strout were professional in their exchanges with the defendant. I'll move on to the next issue, whether or not the defendant...
With regard to the issue of custody, what were we supposed to do with that? I mean, the judge acted as if he had found custody because he went on to be discussing Miranda and invocation, all of which matter only if there is custody.
Well, if there's no custody, then the police never had to advise the defendant of his Miranda rights.
Right, but the police, of course, did.
But they did.
And the judge treated it as if it were custodial.
Okay.
So isn't that an implicit finding that it was custodial, at least at some point during the interview?
I think that's a fair point, Justice Gantz. So I'll move on to the next issue, whether or not the defendant invoked his right to counsel. When I look at the Clark case, well, first of all, when the defendant gets into the interrogation room, he states that immediately he almost states, I probably should speak to an attorney, have an attorney present. So we have to look at that, whether or not that was an invocation of his right to counsel. But this was pre-waiver and pre-being read his Miranda rights. So under Commonwealth v. Clark, the defendant does not have to invoke his right to counsel with utmost clarity. Commonwealth's position would be when he used the word, I probably should speak to an attorney, have one present, that was ambiguous, and as a result, the detectives did the right thing by giving the defendant his Miranda warnings before even questioning him. Once they gave him his Miranda warnings, he agreed to speak to the officers knowingly, voluntarily, intelligently. So this is different from Hoyt, because in Hoyt, once the officers advised him of his rights and stated, having these rights in mind, do you wish to speak to us? In Hoyt, the defendant said, I'd like an attorney. And in this case, they read him his rights. Do you wish to speak to us? Yes, I do. Now, during the interview, the defendant made statements such as, maybe I should have a lawyer, I should talk to an attorney, and as the motion judge correctly found, the defendant, the Detective Strout would always ask the defendant, do you want an attorney, after he made references to an attorney. And the defendant, as the motion judge found, either did not answer or he continued to ramble and speak. So as a result, he never invoked his right to counsel. That would be the Commonwealth's position. If the court did find that his rights were violated, the Commonwealth's position would be that it was harmless error. And harmless because even without the defendant's statements, we had evidence that this was a relationship in which the defendant physically and verbally abused the victim. There was evidence that there was a prior domestic assault and battery in November of 2008 between the defendant and victim. There was also evidence that the weekend before the murder, the defendant had threatened the victim by a phone message saying that if she did not come home, he would kill her bird. Furthermore, on the evening of the murder, or the early morning of the murder, between 1 a.m. and 8 a.m., the defendant made several calls to friends and relatives seeking help because the victim was passed out, she needed help, and there was evidence that he was scared to contact the police because there was a stay-away order. He was afraid because of his prior involvement, he would be blamed for the murder. When the defendant's brother finally contacted the police, ambulance personnel arrived as well as the firefighters, and they described her injuries as being purple, red, angry looking. The bruises and abrasions were fresh, and the medical examiner stated that she had 86 bruises and abrasions, and by the time she was rushed to the hospital, they were only 2.5 to 8 hours in age, putting that in the time frame of between 1 in the morning and 8 a.m. And finally,
What was the defense?
well, the defense was that he should be convicted of manslaughter because he did not have the intent to murder her due to his intoxication from drinking as well as consuming marijuana.
So involuntary manslaughter.
Correct.
That basically he dragged her and didn't realize the extent of harm he was doing when he dragged her into the home.
That's correct. And as the prosecutor properly argued, he did have the intent to murder her, or at least a reasonable inference could be made, because he had the state of mind to, while that was his defense, he still had the state of mind to contact people looking for help. He contacted everybody except the people who needed to be contacted, the police, the ambulance. Would the court like me to address the Rosario violation as well? Or?
Yeah, why wasn't he advised of the rights under Rosario?
So the defendant, the first interview began, it was around 1:50.
Is there a real dispute about the time? The briefs say 12:40 or 1:40, does it?
That was verified at the motion to suppress hearing. So Detective Giacomo stated that the Miranda rights form of the first interview stated 12:50, but she said that was a mistake. It was the commencement of the first interview was 1:50. And then getting back to your question, Justice Spina, the first interview ended at 2:20. That's when they placed him under arrest. And the second interview began about 2:50. And because the issue was never raised below, there was no facts at the motion to suppress establishing when the second interview ended. But the Commonwealth's position is that there's no indication that the second interview was lengthy and then it went, and that it went near 8:20 p.m. So if they had questioned him after 8:20 p.m., that's when you have the Rosario violation.
So when, under your timeline, when should he have been advised of the Rosario?
8:20 p.m. Because that's 6 hours from his arrest. His arrest is 2:20.
And how much information was obtained during the second interview?
Very limited. So I do have it in my brief. I do know that he mentioned that he had drank 24 ounces of alcohol, consumed marijuana, as well as that he, another statement basically that he beat her, or he was guilty of dragging her. I do have the exact language in my brief. If I could just have a moment, Your Honor. Let me see. I do have it, sorry. Of course, at the time that I need to find it, I can't find it. But yeah, it was essentially that he made another admission that he did abuse her, as well as consume alcohol and the marijuana.
So if the second interview only lasted just a few minutes, that would have put it at no later than 3 p.m., right?
Correct.
Why didn't they take him to court at 3 p.m.? It was open.
That's a good question, but I think there was no prejudice because there's no...
But why don't they take him over at 3 p.m.? I
agree with you. They should. The court's still open. I don't know if it's an issue with the magistrates where they don't want new arrests after maybe 2:30, 3 o'clock. In my experience, I've seen that at the district court level. Oh, we're not going to take them. It's like 2:30, 3 o'clock. Maybe that's too much information. But unless the court has any further questions, the Commonwealth would rest on its brief.
All right, counsel, thank you very much.